Sorry, Frank. Afternoon, this is Judiciary Committee on Friday, the 29th of March. I have 2 glasses of water and I would very much like the tree allergies to stop right now. But outside of that, I'm going to roll through, I'm going to go bounce off the list a little bit here and get through some bills where we have clear cross files, where we have cross files that are both in the same posture. And then we'll deal with some other issues as we go along. So I'm starting with Senate Bill 111. Senate Bill 111 is a clean cross file for, I think, Delegate Phillips' bill. There's a conforming amendment. So can you tell us what the conforming amendment does? Turn on your mic.
Conforming the Senate bill to the House bill, and it would add the language that was requested by the judiciary, which is they need to be notified that a minor is involved in the case.
Okay. So there's an amendment. There's a motion on the amendment. Is there a second?
Second.
All right. So any further discussion on the amendments? Seeing none, all in favor will raise your hands, please. 1, 2, 3, 4, 5, 6, 7, 8. That's it. Anybody opposed? Amendments are adopted. We're on the bill as amended. Can I have a motion for a favorable? Is there a second? All right. Any further discussion on the bill as amended? 111. Senate Bill 111. Going once. 111. 111. We did not do 11 yet. We're doing 111. 111 is the bill that we are on, not 11 yet. Okay. Glad everybody's just making sure. Just everybody check your hymnals. All right. 111. The vice chair.
Yes.
Yes. Munoz.
Yes.
Yes. Crutchfield.
Yes.
Yes. Carden.
Yes.
Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Broberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. All right. Favorable motion is adopted as amended. We're going to go now to 273, Senate Bill 273. We'll skip 119 for a moment. There's a motion for a favorable and a second. There are no amendments to Senate Bill 273. Is there discussion on the favorable motion on Senate Bill 273? Seeing none. The vice chair.
Yes.
Yes. Munoz. Yes. Crutchfield. Yes. Carden.
Yes.
Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Motion on 273 is adopted. We will skip over 452 for just a moment while we get some of this other stuff done. What is this? 668 luggage, everybody.
Move second, yes.
Lots of favorable luggage. All right. This is right. All right, there's a motion and a second. Is there any further discussion on this legislation?
No.
All right. The vice chair.
Yes.
Yes. Munoz.
Yes.
Yes. Crutchfield.
Yes.
Yes. Carden.
Yes.
Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes, Conaway. Yes, Kaufman.
Yes.
Yes, Williams.
Yes.
Right? Some county near here wants a judge. Motion favorable and a second, Prince George's County. Uh, There's a motion for a favorable and a second. Is there any further discussion on this? Yeah, we're gonna need like 400 of those.
You don't want the judge? She wants the judge. Don't bring that delegation. I
Well,
know, right?
this. The vice chair.
Yes.
Yes, Munoz. Crutchfield. Yes. Carden. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Pasteur is yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams.
Yes.
Worth noting that on the House version, Delegate Tolles, you are co-sponsor of the legislation, but I just saying. Yeah, pleading the fifth. That sounds fine.
Money.
Okay. This one's from the Senate President. Senate Bill 774. We're on the still first page, 774. Legislation, I think I have the cross file. It sets up a grant program to allow places with a large number of hookah bars and alcoholic beverage establishments to set up further security for those areas, and it's meant to be a statewide bill. There's a, yes, Delegate Valentine.
On this.
All right.
And I don't know if I'm going too far or thinking too far into it, so I wanted to kind of start from the beginning. So what entity, and I'm looking at the bill. I realize it's not a mandatory funding, it's a may, but
There's $250,000 in the budget, this year's budget, apparently.
my question is for organizations and nonprofits, are they the individuals or the entities that can apply for the grant? And where I'm going with this is, and I also see local governments as well.
Yeah.
Where would, if I'm an organization and I apply for a grant and it says in the bill security, but is that uniformed armed type of security and the regular law enforcement? And where I'm going at is eventually a liability concern is if you are, whatever district we're in, and you're a nonprofit and you're contracting 12 county police officers, and we're doing this because there's issues anyway, and they get into a use of force or a deadly force or some type of a scenario, how does that come back to you? Does that go for the liability? And I'm thinking more in terms of like secondary employment, like normally for police. Are they acting in the capacity of their agency? Are they acting in the capacity of the entity? Or the state who's funding it? Where does that fall under? And those are the concerns or just the thoughts I thought of just the other day.
Yeah. So first of all, the grant program is $250,000 at this point. That's what's in the budget. The idea came from a local group in our district, in the 46th district, that was going to work with the Federal Hill Main Street organization to hire people. It's similar to what is done in the French Quarter, where they put together a not-for-profit organization, they bring them together, and they hire, in some cases, I think in Louisiana, and certainly different questions about liability in Louisiana than would be in Maryland, but I think in that case, I think some of them were armed, some were not. It would depend on what that organization's, what kind of exposure that organization wanted to have. I would argue in a $250,000 statewide grant program, it's not going to be a very large amount of money. And what it'd be looking like in the context of my district is something that probably looks a little bit more like the downtown partnership, where there are people who are just visible, who are who are there to help provide assistance to people who need assistance, but also to kind of keep an eye on situations and call for help from police officers when it's appropriate. But in the bill, it doesn't address exactly how that, whether they would need to get liability insurance or anything else. But that, I think, is a decision for those organizations to make, to decide whether or not they want to go down this path at all.
When you say that the ones that are in place, are those individuals in a uniform, or they are plain clothes that you just cited?
So the downtown partnership isn't, the downtown partnership has a uniform. They're not law enforcement.
Okay.
They're people who ride around the harbor. I don't want to minimize what they do, but they deal with a lot of other issues as well that aren't specific to safety. They're a set of eyes that move around, that can identify problems as they develop and call for law enforcement to come in. That is my understanding of what happens also with what we sort of colloquially call the French Quarter example, where they have people who are in the area who can help identify where problems might be erupting, and then they can call for police officers or contact police officers who are in the area already to go in and do the work.
But-
So it's more people on the ground.
Would this be for police though, or would this be for something like what you just said?
It could
Could
be,
be.
but again, I think you're raising the point, the question that comes into play is whether or not a not-for-profit
Okay.
would want to go down that
Oh, so
path.
they could make the decision.
They
So
have to decide.
They have to decide which the one they
And
want.
if they wanted to get armed security,
Okay.
they would have to figure out the liability on their end. And again, even if this were fully funded at $1 million, these grants are going to be small enough that I'm not real sure that that's where some of these organizations might go without other help.
I think I misread. I was reading into it that it was automatically going to be sworn law enforcement.
I mean,
I just assume, I might have misread into it, that that's what it was going to be.
it could be, I think, let me double check.
But it would be up to the
To fund
organization.
security operations could be a lot of different
Things.
Yeah.
Okay.
Yes.
Thanks.
that's the
Thank
point.
you.
So the genesis of the bill, and now, oh boy, don't want to dwell too long on it, but the genesis of the bill is that there are parts of my district, there are parts of probably every district in this room, I mean, that have areas of their district where certain times of the year, in my district tends to be St. Patrick's Day, New Year's, big holidays, where there's a large number of people who come to alcoholic beverage establishments. And there are sometimes crowd control issues, that this is meant to provide support for community groups and for the Main Street organizations, at least in my neck of the woods, it'd be more like the Main Street organizations to get help. To put more bodies on the ground to make sure that they're there. Okay. There's a motion for a favorable in a second. Any further discussion? Seeing none, the vice chair.
Yes.
Yes, Munoz.
Yes.
Yes, Crutchfield.
Yes.
Yes, Carden. Yes, Sample Hughes. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. No. Taylor. Yes, Simpson. Yes, Grammer. No. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman.
Yes.
Yes. Williams.
Yes.
Yes. Okay. Go now. Senate Bill 793. This is across, I think, of Delegate Embry's bill, and it's in the same posture. There's a favorable motion and a second. All right. Is there further discussion on Senate Bill 793? Okay, favorable second. Is there any discussion on 793 with a favorable motion? Seeing none, the vice chair.
Yes.
Munoz.
Yes.
Crutchfield.
Yes.
Yes. Carden. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Williams stepped out. Had to go to JPR. Williams marked excused. Well, here's this local bill, Senate Bill 809. There's a motion for a favorable in a second. Senator Motz's bill, Dorchester County Polygraph Examination. This is the bill, it's in the same posture that we passed the House bill. Any discussion on Senate Bill 809? All right. Seeing none, the Vice Chair?
Yes.
Yes. Munoz?
Yes.
Yes. Crutchfield? Yes. Carden? Yes. What? At their own peril is right. Sample Hughes? Who represents Dorchester County in part? Yes.
Took out the correctional officers is because it's already an existing law. And so therefore, there wasn't a need to be redundant. So that was the clarity that we needed to know last week.
Fair enough. Delegate Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? No. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? You said yes half-heartedly? Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Is excused. All right. Senate Bill 839, we passed the, or sorry, wait, that is not that. It's 890. I don't. One moment, please. I don't have a file for 839. So I'm going to jump over 839 because I don't have a file for Senate Bill 839. Oh, and then the numbers get weird. So I'm going to go to 890. 890. It's in the same posture as the House bill. There's a favorable and a second. Is there any further discussion on Senate Bill 890? Seeing none. The Vice Chair?
Yeah.
Yes. Munoz? Yes. Crutchfield? Yes. Carden? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams is excused. And I got 830 back. So I've got 839 back. There's a motion for a favorable and a second. One moment. Let's go. Senate Bill 839. Is there further discussion on Senate Bill 839? Seeing none. The Vice Chair?
Yes.
Yes. Munoz? No. Crutchfield? Yes. Carden? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams is excused. I'll get it right at some point until she gets back. Okay. Senate Bill 905. This is different than the bill that we sent over to the Senate. It made some changes that were significant. But I'll take a motion. It's a motion for a favorable. There's a technical amendment.
Just a perfect paragraph cleanup. It was a mistake.
Oh, is this the and versus any or something?
This one, they have a penalty section in the purpose paragraph that the bill does not. have.
Why don't you come up and talk into a microphone? There is an amendment. We'll start with the amendment.
Thanks, Claire.
Okay, so the amendment is just technical fix. The purpose paragraph has a penalty provision in it, and there is no longer any penalty in the bill. So we just need to clean that up. And so the amendment just takes that provision out of the purpose paragraph.
Move the amendment.
Motion for the amendment in a second. Is there any further discussion on the amendment? All right, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 21. Anybody opposed? Amendment's adopted. We're on the bill as amended. Is there a motion? There's a motion for a favorable. Is there a second?
Second.
Second, thank you. All right, any further discussion on the bill as amended? Yes, please, Delegate Cardin.
It's different than what we sent over. Is it essentially the same or is
It's
it?
essentially the same, yes, except they added more language, I think that goes to make sure that information is being kept confidentially. Is that correct?
Yes, that the research institution has to enter agreement, that certain information will be kept confidential.
Is there further discussion? Okay, the Vice Chair.
Yes.
Yes, Munoz.
Yes.
Yes, Crutchfield.
Yes.
Yes, Cardin. Yes, Sample Hughes. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. No. Taylor. Yes, Simpson. Yes, Grammer. No. Moon. Yes, Valentine. No. Conaway. Yes, Kaufman.
Yes.
Yes, Williams.
Excuse.
It's excused. So used to doing it that I stuck in a rut. Senate Bill 950. See,
Second.
motion for a favorable. I don't see any amendments. And it's seconded. Any discussion on Senate Bill 950? Seeing, oh, I'm sorry, Delegate Sample Hughes.
Vice Chair is correct. Were you able, or does anyone know, what is the examination process as far as the training is where I'm trying to understand? How much time does someone have to be a forensic examiner?
Why, yes, I do have that information. Hold a second here.
One moment, please.
One moment. Right.
Court's indulgence. That's right. Court's indulgence. Nice. It's like.
Okay, here we are. Thank you. All right, so, with respect to, okay, with respect,
One moment, please, everyone.
okay, with respect to, certification, one must have an active RN license. One must have 18 months continuous clinical experience as an RN, completion of 80 hours of training for an FNE adult adolescent, 40 hours of theory, 40 hours clinical, plus observed exams and assisted exams. And then then we have some FNE pediatric information, which I don't know. Do you want to know that part too?
No, I guess
Okay.
my concern was if it isn't, so it's always gonna be an RN, is that correct?
Yes,
Okay,
yes.
that's the piece I wanted to know.
Yes.
And then the last part is, if the RN that is forensic trained and they are talking to their colleague that is an RN that's not trained, where does that liability fall as far as if the one that is not specifically trained in that space and doing the telehealth, who holds the liability?
It depends. I'm not trying to be funny there, but it
Sure.
depends on the act. If the act is the wrongful information coming from the F and E to the non-F and E, then the liability would be with the F and E. If the F and E gave the correct information, but the non-F and E performed the procedure incorrectly, then it
Mhm.
would be with the non-F and E.
Okay. Thank you. That's what I wanted clarity on.
Mhm.
Thank you.
Further questions? Seeing none, the vice chair?
Yes.
Yes, Munoz. Yes, Crutchfield. Yes, Carden. Yes, Sample Hughes. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes. Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Well then, enthusiastic, yes. Grammar, just a regular yes. Moon, yes. Valentine, yes. Conaway, yes. Kaufman,
Yes.
yes. Williams is excused. Okay. That's a favorable motion on 950. 1036, the cross-file delegate Taylor's bill, which I believe is in the same posture. Same posture as the House bill that we sent out. There's a motion for a favorable and a second. Is there any further discussion on Senate Bill 1036? Which interestingly is one number off of what Delegate Taylor's bill was 1037, and how they coordinated that is kind of remarkable. Be more impressive if they were the same number, but there's always, next year or something. Delegate Taylor?
3-7,
Really?
which is also my birthday. So all of those things. Am I making it worse?
No. It's just
That's a lot. It's a lucky bill. If we
Have
don't move
to-
it now, must be separate.
call a number person. There's a motion for a favorable and a second. And before we get into more discussion on the bill, any other discussion on the bill? Seeing none. The vice chair?
Yes.
Yes, Munoz.
Yes.
Yes, Crutchfield. Yes, Carden. Yes, Sample Hughes. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Enthusiastic, yes. Simpson. Oh my, yes. Grammar. Regular, yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman.
Yes.
All right. Stop this time. It's local bill, Senate Bill 1038, Anne Arundel County Human Rights or Human Relations Commission subpoena enforcement. There are no amendments, I don't believe. There's a motion for a favorable and a second. Is there any further discussion? Delegate Roberson.
Just quick question for anybody who's from Anne Arundel. Do any other counties have this Human Relations Commission have this authority? Are we aware of that? So Prince George's County does not? Okay.
Uh-oh, that's a delegation shift line.
Okay, my question has been answered.
Believe it has. Okay. Any further questions? We got the motion in a second. Any further discussion? Seeing none. The vice chair from Anne Arundel County?
Yes.
Yes. The ranking member from Anne Arundel County? No. Crutchfield? Yes. Carden? Yes. Yes. Sample Hughes? No. Embry? Yes. Pasteur? Yes. Tolles? What is that? Yes? Yes. Schmidt? No. Simmons? Yes. Boucher? Yes. Phillips? Yeah. Yes.
Because I did just do the research. Baltimore, I thought it did. Baltimore City Human Relations does have subpoena power.
Yes. We're past your vote. Delegate Roberson. Yes.
What?
Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 in affirmative. The motion is adopted. All right. Delegate Kaufman. House Bill 115.
Favorable.
Not yet. We have an amendment that the delegate has, I think we have an amendment that the delegate,
Move the amendment.
do we, they have it. Okay. I may not have, but I think I know what it says. I think that would be great. Delegate Kaufman, why don't you explain the amendment?
Okay, well, this is actually a great idea that came from the chair himself. We collaborated together on this bill. We collaborated together on this bill and we both wanted to support victims at a time of potential re-traumatization when the person that victimized them or their next of kin gets out. But the chair, and I agreed with him, felt that instead of the victim services coordinator being the person that the family members should contact if they have questions or concerns, the better venue for those calls was the Maryland Crime Victims Resource Center. And I'm very proud of the fact that this legislation has bipartisan co-sponsorship, including Delegate Grammer.
We're on the amendment. There's a motion and a second on the amendment. Is there further discussion on the amendment? Just to go a little further, the argument here is that you could have people moving around the state after a crime happens. It's better to have a statewide organization where people can go to and make phone calls to, as opposed to calling the state's attorney's office from where the crime occurred when you may be living in another county and they may not be as familiar with the other services that are there. That's the rationale behind it. Thank you very much. All in favor of the amendments, please raise your hands. Yep. Anybody opposed? All right, we're on the bill as amended. That's a motion for a favorable. Is there a second? All right. Is there further discussion on the bill as amended? Seeing none. The vice chair?
Yes.
Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Oh, that is possible. Erican is a me too. Taylor? All right. Yes, and me too. Okay. Yes, and me too for Taylor. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes, and a me too. Conaway? Yes, and me too. Kaufman?
Yes.
Yes. Williams? Excuse, Munoz asks to be added on. Simmons asks to be added on. Phillips asked to be added on. Schmidt asked to be added on. Pardon, why not? Says should be added on. Is that you? That's you. Okay. Thank you. All right. Well, she is not here, so we're gonna skip 1063. Huh? Okay. Delegate Williams isn't here, and so we will wait until she gets back to do 1063. 1065 is the cross file from a questionable sponsor. There's a motion to match the vote from the Senate cross file. Any objections? Hearing none, we will simply match. All in favor of matching the vote from the Senate cross file to this bill? All in favor of raising your hands? Anybody opposed? Anybody object? Nobody objects? Fine. So the same as Senate bill. All right, so now we'll go to the other bills and we'll come back to. Did I have to do, wait a minute, I had to do this? I had to do a conforming amendment. All right, never mind. I'm gonna bring back 1065 because I have. All right, second, somebody?
Second.
All right, all in favor of reconsidering, say aye. Aye, anybody opposed? No, great. Oops, there's an amendment. It's a conforming amendment to the Senate bill, so we do have to do it this way. The bill is a conforming amendment. The House bill didn't include a reference to hookah bars. This now will get added into the bill. There's a motion for the amendment. Is there further discussion on the amendment? Seeing none, all in favor of the amendment, raise your hands. Anybody opposed? Amendments adopted on the bill as amended. There's a motion to match the votes again and a second. Does anyone object? Seeing no objection, we'll do that way. There's no objection. We will have the votes from the bill that we heard a moment ago be the same as on this bill. So that's fine. And we actually adopted the amendment, which we had to do. Great. All right. So now, what's your pleasure? 4 bills to go. Which one do you want to do that? All right, so why don't we're gonna begin with the bill that we are second. We're second on Senate Bill 119. And I understand that there are people with questions. We don't have any amendments, I don't believe, that are being offered here. The bill was passed on a favorable motion on Senate Bill 119 from the Senate 17-6. And so I'll hear a motion on, there's a motion for a favorable and a second. Could we please have explanation on Senate Bill 119? And that is Holly. One moment, please.
Okay. Okay, so as Chair said, we're secondary. I think for context, so in 2023, we passed chapters 246 and 247. And this was the Reproductive Health Protection Act, which established protections for information related to legally protected healthcare when that information is sought by another state. The acts also prohibit a health occupations board from taking disciplinary actions related to certain provisions of legally protected healthcare and had some other provisions related to those prohibitions. This bill expands the definition of that legally protected healthcare to include all gender-affirming treatment that is lawful in the state. And as a result, gender-affirming treatment is subject to those prohibitions that are in chapters 246 and 247 of 2023.
All right, Delegate Munoz, please.
So that law that was passed, I believe if I remember correctly, it had to do with protecting abortion as a healthcare procedure and the providers. And so now we're expanding that to include the whole, like another field of gender affirming care. Is that correct?
Yes.
Yes.
And does this bill include the care of minors as well as adults?
There's no age restriction.
Holly has said that there is no age restriction in the bill.
So what would that look like practically when we're talking about children undergoing these medical procedures in the state of Maryland?
So gender affirming treatment is defined in the bill as any medically necessary treatment consistent with current clinical standards of care prescribed by the person's licensed healthcare provider for persons or individuals' gender identity. And then gender affirming treatment goes on to include hormone therapy, hair alteration, alterations to voice, laser treatment. I mean, there's a list of 11 different things that are included under what gender affirming treatment looks like.
And so then who are we shielding from getting this information if children are undergoing this treatment in the state of Maryland?
Let's go to Delegate Moon.
Mr. Chair, I happen to be the crossfile on this bill. So I can give a
So
little,
let's just do
Yeah.
this. If you have a question about, I think that Holly has answered the questions about what is in and out of the bill. If there's questions broader about the broader policy, we're gonna go down to Delegate Moon. So I'm
Yeah, thank
kind of
you.
letting Holly off the hook here
Thank you,
for a
Holly.
second. So go ahead.
so I don't, honestly, guys, I don't think we need to get into a whole relitigation of the gender affirming care bill that we had in prior years. That policy decision was really about extending Medicaid coverage and things like this. It was about insurance coverage. The bill, all it does is it shields people in Maryland residents, patients, and providers from out of state punishment for things that are legally allowed to be done in Maryland, medically necessary between a doctor and a patient. So those decisions were already made. The states went in different directions. Maryland has its own set of health policies. And so the bill simply stops if another state, Mississippi, say, passes a law that criminalizes this stuff, fine, that's fine for them. But they can't subpoena or extradite someone from Maryland to go face prosecution in Mississippi under a different state's decision. That's all this bill does. And so it covers the doctors from occupational licensing, suspensions and penalties from other states. It stops extradition for criminal prosecution from other states. But again, if it's illegal in Maryland or the procedure is not proper, or they somehow violate law, they're punishable fully within Maryland's occupational licensing and criminal system. But again, other states have decided to criminalize some of this activity. And in some instances, Mississippi, I think, has decided to criminalize even over the parents' objection. So if the parents have chosen and the doctors have chosen a medical course of action, some states have decided the state is overruling the parents' rights on this. And so Maryland is stopping its residents from being punished by other states' laws. That's it.
So if we had the hypothetical of outside family from, say, I don't know, Virginia, just hypothetically, and you had a mother bring her son to Maryland to undergo gender affirming care and sterilization here in the state of Maryland, the father could have no cause of action then. And if a year later, the son was like, oh, I don't want to do this anymore.
That's not accurate. I
Okay,
think
fair.
family law, custody, and all of that decision-making would still apply under, so if you're having a dispute about a kid's religion or something like this, these are custody issues that would still happen. Whoever has custody of the kids has that decision-making right. Again, all this bill does is say if the state in Maryland is not going to participate in punishment from another state on the grounds of that procedure being not legal in that state.
But what if custody changed and the father got custody and then wanted to get information about what had happened to his child?
So they would have all the normal information that a parent has available to them about medical decision-making. I mean, these are ordinary custody things that happen and disputes that happen. But if they're trying to enforce a criminal law in their state against a medical provider or patient in Maryland, they're not going to be able to subpoena or extradite. But again, that's not going to stop a normal family law cause of action from happening.
All right. Okay. Now Delegate Eric and Conaway.
Thank you, Mr. Chair. Maybe Delegate Moon can respond or counsel. So can somebody walk me through the med mal situation? What if there's an adverse outcome from a surgery, or in the recovery period, let's say the child goes back to Virginia, there's a infection that ensues, child dies. Obviously, criminal charges should be brought against the practitioners. Can the state of Virginia sue the practitioners in a situation where there's medical malpractice still?
Yeah, sure. I don't think this is gonna stop any normal standards of care from being enforced.
Okay, so, but the bill expressly allows for those types of actions, so, and can there still be criminal charges brought? In those, Claire looks like she wants to say something. She's.
Yeah, they're saying that would be just a civil,
Civil case.
Yeah, not.
Okay.
Not.
Well, okay, so but in Virginia, maybe there would be, so there's no criminal law where it's like gross negligence where we can like say the person was criminally liable for the harm that was caused to the child.
I've not heard of that.
Hypothetically, I think that there's potentially a gap there. That's my worry. So a doctor here is acting in a criminally negligent manner. Child gets home to Virginia, dies of a post-operative infection due to criminal negligence. Now this bill says you can't subpoena any information related to, if you're going to be criminally charging someone.
Well,
Virginia has lost their
that's
criminal
gonna be
cause
a
of action.
Maryland crime anyway.
Yeah, not if the child died in another state.
But the act,
No, I don't think that's.
the act occurred.
Yeah.
Thank you, Mr. Chair. But the act occurred in Maryland. And so therefore, the adjudication of that crime would take place here in Maryland if that were to occur. There's nothing about this bill that would prevent a malpractice suit from occurring and actually being successful if malpractice actually did occur.
Okay, so I mean, just from the only things that I know about is a lot of times if somebody dies, the charges come in the location the death occurred.
So let me go, so this was Delegate Williams' bill from Delegate Williams' bill last year, but I'm reading on page 6, at least to the bill is introduced, and I still think is in the language of the bill. It goes in line 26 through 28. The interstate investigation or proceeding well, I'll go a step before that. The section doesn't apply if to an interstate investigation or proceeding described under section C, if the interstate investigation or proceeding concerns conduct that would be subject to civil, criminal, or administrative sanction if committed in the state. So in other
Okay.
words, if it's illegal here,
Okay,
and then they were to go back to Virginia and die, because it would
They
still be a criminal, it would still be a problem in Maryland, they could still do that because.
okay,
Yes.
because of
that makes me feel better. Okay,
Right.
that's all I needed to know. Thank you.
Right. Delegate Conway, then for Valentine.
Thank you, Mr. Chairman. I just love it when my questions change when it's my turn. So if a child, parents have joint custody and one parent takes the child in for whatever they do and the other parent doesn't agree with that, then can charges be brought by one parent against the other parent or against the,
Contempt of the court.
or against the, well, this was kind of alluded to two questions before.
So, not to make light of it, but think about it as if two parents had joint custody and joint legal custody,
Yes.
because really what we're talking about is joint legal custody, the
Yes.
decision making on medical procedures. Think about if it were someone got braces, all right? And one parent didn't want it because they have to pay for it now, right? And they didn't want it. And they said, I didn't want you to have those braces. But they don't have to deal with that in family law. It's not a crime to do that if the person did it for the right reasons or the reasons that they thought were the right reasons.
Okay, well, we were originally talking about gender redenification.
Okay, so let's use gender affirming treatment.
Yes.
It also says in the bill that it has to be that which is medically necessary. So that's why I was using the braces as an example, because it was a medically necessary thing. But if we're saying gender affirming treatment, we're talking about what is medically necessary. So the court would look at that and say, was this something that was medically necessary? And then they'd look at the fact pattern and still use family law to go with it. Now, you know, if you have joint legal custody, then you each have the ability to do what is medically necessary for your child. You don't have to necessarily call up.
Yeah, well,
the other
in
person.
the example earlier, just to slow you down a little bit, we were talking about someone coming from another state.
Mhm.
So one parent might take their child from one state to this state, have the surgery done, and then go back to the other state, right? Without the other parent's knowledge.
Right.
So in that type of case,
It would still be, we would still look to the family law. We would still look to family law in the sense that whatever the judges have, whatever the parties have been ordered within their family law case or whatever custody level they had, if they had joint custody, that other party who's in Virginia, who may feel like they have been, they weren't involved in the decision-making, they could still go to court and argue that very fact. That, you know, I should have been advised, I should have known, et cetera. They could still argue that.
would the doctor or physician have a certain responsibility to know whether or not this child is under joint parental guidance or single parent?
Now, I think that's a good question.
Well, that's
I
the
think
question I was trying to get to.
Well, I think that's a good question. And the reason why I think that's a good question is because doctors don't have any type of requirement to ask whose custody or who has custody or anything like that. But they can ask that question if they want to. They could very well ask that question, but they still wouldn't be criminally liable in Maryland for performing the surgery.
But could they be criminally liable in Virginia?
No. I don't believe so because the surgery was performed in Maryland. And that's the whole point of the bill. We're trying not to have people go back home and then, you know, get prosecuted. That's what I think. But Delegate Moon.
So let me keep clarifying aspects of this. So I just went back to the text of the language in the shielding law, and it shields as to criminal subpoenas and extradition for those things that are not criminal in Maryland. But if you're kidnapping someone, essentially, that's criminal. Okay, so if you're investigating something that's illegal to do in the state, you could continue along that path. If it's not, then you're really talking about a civil matter, a family dispute or something like that. And a lot of this is just not going to apply. And we keep using the term surgery. I want to be very clear about this. Surgery is not most of these cases. It's therapy and things like this. And when you say medically necessary, what we're talking about is suicide prevention in most of these cases, that suicide prevention is one of the underlying reasons for people engaging in therapy. And again, in some states, they have made even the therapy with suicide prevention as its goal illegal, including in some states if the both parents have decided to go that route. And that's all this bill is trying to protect people from, that aspect of it, okay?
Delegate Valentine.
I believe Delegate Moon answered my question. Mine was in a custody dispute where there wasn't an agreement. There is a situation where some of the bills we've heard this year where one parent is being denied access to that child and is in the contempt process and the motions process to get cut or to be able to visit the child. And during this interim, the other parent brings that child to Maryland, something is performed. Would he or she have access to those records? Because they have been trying everything and there is no formalized custody agreement. That's the kind of scenario I was trying to look at. Would he or she, as the other parent who's been denied to see their child, be able to get those records to find out what did happen in Maryland?
They could always petition the court to find out. You can always go to court and petition and you present your reasons as to why, why you want to have this information.
So this bill would not prohibit that parent from
doing that? No,
in that
not at all.
situation?
Not at all.
Okay.
No. I had a question actually for Lauren, but then again, my question was for Lauren. I wanted to ask you if, since we were talking about this, I hate to muddy the waters, but it does bring up the question on the uniform child custody. I was trying to see if that had anything to do with it. But you know what? I'll talk to you about it offline, because do you see where I'm going? I was, yeah. Okay, thank you.
Yes.
Thank you, Mr. Chair. So we've talked a lot about children, and obviously we're all concerned about how this would impact them. But hypothetically, if we were talking about an 18-year-old who came from out of state to the state of Maryland, presenting with mental health issues and was given this gender affirming care, perhaps given surgery, goes back to their state where this entire field of medicine has been deemed dangerous to the public and is therefore illegal, and a year later finds that they are worse off mentally, they're more suicidal, their life is not better, it's in fact worse, and they themselves want to bring a cause of action because they believe they were misdiagnosed, they were mistreated. Would this bill then take away their right to assert their own legal rights?
Depends on what they're bringing it under.
No, I think you wouldn't be, no, you wouldn't be precluded from bringing an act yourself based on I'm thinking what you're describing is malpractice, medical malpractice. You wouldn't be.
Because in Maryland, we would say it's gender affirming care, but in another state, they might call it medical malpractice. It's defined differently in different states.
Yeah, but the action would be brought here.
No, it'd be
sorry.
brought there.
What is your question again? I'm trying to.
We would consider the standard of care, then we should protect them from being charged with malpractice in the state.
You turn your, yeah.
I think
Go
that's the
ahead.
whole bit of the bill. I mean, I think so, right?
Say what you said again, please.
Mr. Chair, if we believe that it's the standard of care, but in another state, they might define it as malpractice. The whole point of the bill is to protect the people that have been treated or are treating for that, what is considered the standard of care right here in the state, by not releasing information to a state which would not deem it the standard of care.
Even if it's by the patient themselves.
I guess I'm just trying to understand the question. So the patient came here
As an adult.
as an adult. A doctor felt that it was medically necessary for them to receive this treatment in
Yes.
Maryland. And they got the treatment from that
Yes.
doctor here in Maryland.
Mhm.
They moved to, or so
They went home.
go to another state,
Mhm.
and they feel like the treatment isn't helping them.
It made things worse.
It
Mhm.
actually made things worse.
Mhm. And the state that they reside in considers this form of care criminal negligence.
Right, but I guess my question is, I don't know if that person would have a cause of action regardless, because they voluntarily sought the care and got the care that they sought.
Even if the diagnosis includes their mental health being.
Yes, because the doctor, based on his or her medical opinion, made the decision that this was the care that they need, and they accepted the doctor's opinion.
Okay, so Mr. Chair, is it possible to hold this bill for the purposes of an amendment?
We'll hold it until Monday. We'll hold it until Monday at 1 o'clock when we were gonna have another voting session, and kind of wondered whether you were going in that direction anyway, and that's fine. We'll hold it until then. We're secondary on it anyway, but we will need to act on Monday with that legislation with Senate Bill 119. All right, now. What do I got here? Okay, so you're here now, so we can do House Bill 1063. I wasn't going to do House Bill 1063 without Delegate Williams. Yeah. There's amendments.
There's lots of amendments.
Lots of amendments. And do you want to take a swing at what the amendments do, Delegate Williams?
Sure, or should we do a motion for the
We'll
amendments?
do the motion for the amendments. There's a motion. Is there a second? Second, all right. Got a little exciting there for a second. Delegate Williams, please.
Yes, so there's lots of amendments on this bill. I apologize in advance for that. There were some initial drafting issues. And then we finally, anyway, long story short, these are what the amendments do. They remove all the civil forfeiture procedure. Okay, I don't even know what pages these are on, but give me one moment, please.
One moment, please.
Yeah, a lot of the bill is gutted. So,
The bill is gone, so it's gonna be easier for you to describe what's.
it's probably easier for me to describe what's left in the bill. So let's just start on, I'm looking at the reprint of the bill. I guess this is starting on page 3 of 29. So let's start there. So we modified the crimes that are listed under the bill so that it's really only crimes that have a penalty of 3 years or more under the code, with probably like one exception. And you'll see that exception down on, scrolling down to page 4, number 12, removal or falsification of vehicle identification number under 14-107 of the transportation article. And we felt it was important to keep this in because this is something that according to the police officers and the state's attorneys, and even our attorney general, are seeing when people are stealing cars or stealing parts from cars, removing the VIN numbers from those cars and from those parts in an effort to try to resell those parts and resell the cars. So we thought it was important to keep that in, as well as the abuse and neglect of a vulnerable adult, especially when it comes to matters dealing with, say, nursing homes or other facilities that may not be acting in a proper manner. So that's really those are really the big changes to the bill. We removed all of the civil forfeiture stuff. So that's no longer in there. So that shouldn't give anyone any angst anymore. And that's pretty much all the bill does now.
Any questions? We've got the motion already on the amendments. Are there further questions on the amendments? Delegate Tolles.
All right, so can you just say what the bill does?
Yes, the bill basically just adds some additional crimes to our existing gang statute. That's all it does.
The aforementioned crimes.
Yes, it adds to that list. That's all it does now. And I can scroll, and like I said, those start on page 3 and goes on into page 4. So if I scroll back, we are adding a felony violation of Title 8 of the article, which basically deals with fraud and related crimes, bribery under Subtitle 2, false statements under Subtitle 5, impersonating a police officer. I think that's important. Threat of mass violence, of violation of child pornography, felony violation of insurance, basically insurance fraud, as I mentioned previously, removal or falsification of a vehicle identification number. And the last one is abuse and neglect of a vulnerable adult. Those are the crimes that are being added.
Oh, I'm sorry, go ahead. Delegate Tolles, sorry.
Thank you, it's okay. And as a follow-up, could you give a hypo in terms of where you would use this new law?
Well, it's just adding to the existing law. So it's not really a new law, but just any type of where
Some
you
new
have
changes.
It's just some changes to existing law. So any type where you have where you suspect that you have gang activity, whether it's a gang, a crew, mafia, all of the above, is where you would use these. And it's just really updating the gang.
Give me a hypo.
A hypo. Okay, it's a little hard for me to do it. Yeah,
Nursing home where you have multiple people who engage in thefts inside the facility, and they work together and they coordinate. It's something more than a conspiracy. This is something that a criminal organization is there for that. The other thing that I think this comes, I think, from the state's attorney in Prince George's County, where they've had people who actually go out and steal license plates, which makes it easier for them to then steal cars, where they switch out the license plates from other cars, and it makes it difficult for police and law enforcement to be able to track down those cars.
Right.
The other one, I think there was what was the police officer, the law enforcement,
Or
the
impersonating a police officer.
impersonating
And
a
we've
police
had those
officer? Yeah.
cases,
Where
unfortunately.
people, yes. Do they happen commonly? No, they don't happen commonly, but the idea is, again, for if you have these situations where you could have a criminal organization participating in these things, it would extend those length of the number of different crimes into those crimes as well.
Will this help with a increase in auto thefts?
The hope is that it should, especially if it's done in coercion with multiple people. If it's, the ex-gang posse going out coordinating to steal cars for the purpose, as I mentioned earlier, to sell the parts of those cars or to sell the cars themselves on the black market, whether it's on Facebook Marketplace or whatever the case might be, then that is to help them.
So
to help capture them.
Let me offer a hypo. So if you have a child that's, underage, I don't want to get this whole underage thing, but if you have a child that's still in a car and they've done it multiple times.
And they're
does
part
that
of a crew.
And that, but
And
it
this
has
is
to
what
be
the crew
proven,
does.
if it's proven, right?
Right.
That they're part of a crew, which is probably a high bar to prove. Thank you, to prove. Then is this where this will come into place? Because like I said, it's a very high bar. How do you get at stealing, the cars and being able to prove that? Is this helpful for that? Because we do have a real issue, a huge issue with that in Prince George's. I just want to make sure that we're putting something that could actually deal with that issue. It's my hypo.
But I mean, that would just be general theft, and that's already, that would just be
Okay.
general theft.
Yeah.
And that's already, I think it's already in there. So yeah.
I think the vulnerable adult thing, to Delegate Crutchfield's
Mhm.
point, is where I think the state's attorney is going for in Prince George's County a little bit more.
Mhm.
Is you could have groups of people like in a nursing home or an assisted living that work together to steal from some of the people who are in those facilities. And I think that goes to that is what I remember from the briefing or the hearing on the bill as well. It's one of the things she's seeking to do.
So not so much stealing cars, more so dealing with this vulnerable adult population.
Yeah, that's one of the crimes that they would extend the criminal organization statute to include. Yes. Delegate Conaway.
In a case where you have just two people, well, I guess to have the organization, you have to have three.
More than two, probably.
More than two, okay. So you have three people. You have one person who steals the license plates. They provide stolen license plates to their cousin, another person. That person steals cars by themselves. That person sells the stolen vehicles to the person at the chop shop. They do this 2 times, these 3 people. Now they could come underneath for this.
If they're doing it in coercion with one another.
Yeah, they're doing, they're an organization.
Yeah.
1, 2, 3.
Mhm.
1, 2, 3.
Yeah.
Okay, thank you.
Delegate Eric here.
Move the previous.
In the seconds, we're gonna go ahead and I don't think there's further discussion on this anyway, is there? I don't see anybody else. All right, so on the amendments, all in favor of the amendment, please raise your hands. Anybody opposed? All right, so we're on the bill as amended. Is there a motion on the bill as amended? Motion for a favorable and a second. Is there further discussion on the bill as amended? Vice Chair.
Okay. Just want to know, Delegate Williams, is the bill now in a posture that gets to the original public policy that you were trying to get at?
Yes, it does, actually.
All right, thank you.
Anyone else? All right, seeing no other discussion, the Vice Chair.
Yes.
Yes, Munoz. Yes, Crutchfield. Yes, Cardin. Yes, Sample Hughes. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes.
Thank you.
Yeah, asked to add on, Tolles did. Schmidt.
Huh? I explained my vote.
Oh, can you explain your vote? No, she's not asking to add on.
That's
You can-
correct.
Yes.
So I was just going to, I'm not really sure what the public policy is. I do think that we have a huge issue with car thefts, and I was hoping that it'll be able to get to that issue of dealing with car thefts in our county. And I understand the issue with the license plate readers and so forth. And as a chair, agreed that is a very high bar to be able to, prove what was indicated in the conversation, in the debate rather. So look, I'm going to vote for this, but I do have concerns about whether we're really getting at what I know some of our true issues are in Prince George's. And I don't want us to create something where we are not getting at the root of our issue and just, charging people, again, without really getting at what we are really experiencing in Prince George's is the high level of car theft. With a license plate or without a license plate, people are stealing cars. And I hope that, we can really get to that. I'm going to vote for it, but I do have some concerns. Thank you.
Delegate Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Erican, me too's.
I want to explain my vote real quick.
Yes.
So I understand the concerns of Delegate Tolles. I just wanted to point out that actually, if you look, we're essentially redefining what an underlying crime is. And if you look under number 3, there's unauthorized use of a motor vehicle. It's already an existing code, and theft already in the existing code. So we're just adding things, but those crimes I think you're worried about in your community are actually already in here under organized crime, and we can charge right now for it. Yeah. And oh, you weren't? Oh, I thought you were worried about being unable to charge for vehicle theft. I know. I just wanted to make sure that we all understood that theft of cars should already be in here.
I believe Delegate Erican wanted an add-on. Delegate Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. And an add-on Williams? Yes. Okay. All right. 2 more. I sense holds in our future. Senate Bill 452. Senate Bill 452. The Senate. Oh my, so many amendments have been offered. Oh dear. Oh dear. There's a committee amendment that would effectively take the bill back to the posture where we passed it out of the House. That didn't take long. All right. So that's what there's an amendment from me to do just that. Now, if we're doing this, there were other amendments in the file that would go and add other groups and do other things. So I'm just being direct with people. If we're doing this, then I'm not going to consider any of those. So if people are in their feelings about that, they need to say something right now. And then okay. And so just to be clear, that's well, we did that. So we moved and seconded the motion, and now there are people will do discussion on taking this back to the House version of the bill. Delegate Taylor, then Roberson.
Yeah, I'm just uncomfortable without knowing what all those other options are.
I understand that. I mean, we could talk about what the Senate bill, what the Senate bill does. We could do that too. Why don't let me take Delegate Roberson's question, and then we'll come back and we'll lay out what the Senate bill does. Delegate Roberson.
Thank you. Mine is just on procedure. If we, so I'm clear, being new to this, if we take this back to the House version, then we send the Senate bill back to them.
We're sending the Senate bill back to them with the language that we passed in the House bill.
Yes.
Then if they don't like that, then they will say that they do not concur in the House amendments that basically change it back to what we sent over to the House bill. And so we will decide if Then they would decide not to concur, and then they would, generally speaking, propose a conference committee to work out the differences of the two houses.
Understood.
They could also decide not to send a conference committee and just say, no, we don't like your amendments at all. We want you to take our bill the way that we sent it over there, and we're just gonna sit here and stare at you until that happens.
Understood.
We can also do things like that.
Got it.
And that's part of the fun of this time of year.
Got it. Thank you, Mr. Chair.
I am gonna get to Delegate Taylor's point, but so Delegate Grammer, do you want me to talk? Why don't we do what the Senate amendments do, just so that people are clear what the Senate amendments do, and then we can go from there. And that is Holly, and if I talk long enough, then she'll be able to walk over here and get here. And then Holly will be able to sit down and look at her computer for a second, let us know what the Senate bill as sent over does. Holly.
Okay, so the Senate amendments bring in lodging establishments, which are defined under the big business regulation as an inn, hotel, motel, or other establishment that has at least 4 rooms. It also brings in health club services, which includes health spas, salons, weight reduction centers. There's a list. If you go down to page 3, the Senate redefines recreational facility. It does not include a lodging establishment as defined under the business regulation, which I just said. And it also says that the entire section does not apply to a health club services agreement as defined in the commercial law article for health services to be rendered for an adult. And that is what the amendments do.
So basically what that means is the Senate sent over was 2 amendments. One amendment says that if you're dealing with health clubs, with waivers in health clubs, they can't prohibit the waivers for adults. They can only prohibit the waivers for children, okay, in health clubs. And in the hotels, they basically said hotels that are only hotels and not also recreational facilities, they are excluded from the bill. So you can't prohibit them from having waivers. The fact is that hotels don't have waivers. You don't sign a waiver when you go to a hotel. So that amendment, it was accepted by everybody. So I just put it to you that way. So that amendment doesn't really mean anything either way, whether we take it out, we leave it in, or anything. Does that make sense?
Delegate Grammer, because I skipped, oh, wait, no, Delegate Taylor was one. Delegate Taylor, please.
Thank you. I just wondered, you're saying prohibiting waivers. Does that mean if they have a waiver already that it's null and void at this point going forward? Or are you prohibiting going forward from having a waiver if you're a business that
prohibiting them from asking their patrons to sign a waiver of their negligence. So what the bill does is says that you're not right now in Maryland law, it's questionable, but you can, a hotel could put in front of you, well, if you're going to come into our hotel, you have to sign this waiver that if we screwed up, you can't sue us. And what we're doing is we're saying, this bill is saying we are prohibiting you from doing that. But we are saying that for hotels, we don't really care because hotels they don't give waivers.
Just bouncy house.
Yeah. Just bouncy houses and, water slide companies.
All right, now. Grammer, then Conway, then Tolles, then Phillips.
Thank you, Mr. Chair. Thank you, Mr. Chair. So the reason I moved this amendment, I actually drafted this amendment as well, is the bigger policy question. And is if we feel that a party shouldn't be able to secure itself against liability for negligence, that should be the case across the board. I'll also note that the party that amended themselves out of the bill was Marriott, the one with the giant tax credit. And the one that can afford the lobbyists. So I think if we're going to do this, we should pass it clean, the same way that we passed it out last year, and that it almost passed on sine die. I agree with the policy question. I believe this committee did unanimously as well. And if we start getting into all these exceptions for like who can be negligent. I think it's just ridiculous here. And this can be a real quick conversation and we can move this clean.
Chairman, is this the bill where one of the people that came in to testify said that you can't really waive your rights? I don't really want to say who said that, but actually Frank Boston said that.
Oh.
I don't recall.
I did, because I asked the question.
It was on the House bill. Same bill, it's the Senate version.
Says this was from this bill.
Yeah.
Yes.
So even if you sign that you waiving your rights, you really can't waive all of your rights.
Delegate Cardin, you want to respond?
The problem with that is that there have been court cases that have countered that.
Right.
And so this, to a certain extent, is clarifying that exact comment, which is what Mr. Boston said, which was, we just want to make sure that that is actually, that you shouldn't be able to waive somebody else's rights. And that's exactly what he did. So
I'm gonna, okay. Do you want to respond to Delegate Phillips, then Tolles and Williams and lots of people? Yeah, okay.
So I just wanted to make sure we were clear.
Good.
What this bill is saying is that it would be against public policy.
Right.
So therefore the waiving of, because they could still have you sign a waiver. And the signing of the waiver is not going to be illegal. The clause itself is no longer within public policy. And so therefore the clause would be null and void. So we might still go to you know, where you jump and you climb and all that stuff, and they may still have that waiver form. But that line, that clause would no longer be actionable in the court of law in Maryland. They couldn't protect themselves using that clause. I just wanted to make sure we're clear. Because there are a number of places you go and they're gonna make you sign a waiver anyway.
Right, I asked about that. I
Right.
specifically asked
That's what I'm saying.
about that. Okay. All right.
That's
So
that's what Frank Boston was saying.
Right, so therefore it could stay in the contract or whatever, you could sign it, but it's not enforceable, basically.
Under this.
Under this.
Correct.
Right.
Now the comments on the comments on the comments. Vice
I'm
Chair.
sorry.
I'd like to comment. What you can't do is waive away gross negligence. So you can say I'm waiving negligence, but you can't waive away gross negligence. For instance, if you're at an amusement park, one of those water slides or whatever, and they've drained the pool and you didn't realize they had drained the pool.
Oh.
Okay, and you go down and you get hurt, you can't waive that away. They can't say, well, you signed a waiver, so it's all good, because that would be gross negligence. Do you agree?
They haven't inspected it.
Well, they haven't, yeah.
For years.
Yeah, they haven't inspected for years or something of that standard. There's an alligator in the water or
And they
something.
know
like
there's
that.
an alligator.
And they know there's an alligator. It's a big alligator.
But you wanted to challenge the alligator.
You know, that's different. That's different.
No, no.
That's assumption of the risk.
Oh God. Oh God. It's my fault. It's all my fault. It usually is my fault. And sharks. All right, everybody. We're going to come back to the bill now because a few more people want to ask questions. Delegate Toll, this is just me being nice.
Thank you.
Delegate Tolles.
The company wouldn't be held liable for the alligator because they can't control if he walked in there on his own. That would be force majeure, so they couldn't deal with that. But yeah, unless they put the alligator in there. But I digress. My simple question is for council is when they are talking about like hotels in reference to the waivers, what if the hotel has a weight room as part of the hotel, which generally all hotels generally have a weight room?
Delegate Cardin.
Right, that's exactly the point. So this is where the side that those of us who want to see this bill pass say that I have been to many, many hotels and never have I had to sign a waiver
Mm-hmm.
to use the weight room in a hotel. They just don't, generally speaking, as far as I know, now there could be some exceptions. Generally speaking, hotels don't require it, which is why that's not an issue. But yes, that's the point of the amendment, is for that exact reason. They want to be exempted out so that if there should come a time when they want to have a waiver that you sign to use their weight room, that they do not want to be prohibited against public policy, as Delegate Phillips said, for them to be able to enforce that waiver. And but it doesn't exist right now. There are hotels that that are associated with recreational parks. For example, I
Right.
think Jolly Rogers has a hotel that's affiliated with it. I know that Great
Which-
Wolf Lodge has a hotel that's affiliated with its park. Those would not be part of this amendment that exempts hotels, because that is a separate entity that would be excluded from this amendment.
And that was my next question, one that was, places that have like Great Wolf Lodge that we have now here in Maryland. But so that was my follow-up. But to your original point, we don't, when we sign our receipt and, check into the hotel, there's all type of language. I can't remember if that type of language is on there to say, hey, if you get hurt in any equipment, and it was to say that, some hotels have, just a treadmill and a bike, and that's it. Some are more expansive. And so how do you differentiate between those particular hotels?
So then I would just support Delegate Grammer's move and pass the bill clean, if that's what you think.
Unfortunately, I agree with Delegate Grammer. So it's always a first time for everything. But I'm thank you, Mr. Chair. That answers my question.
Yeah, so, my first comment is, I think pigs are flying, because I agree with Delegate Grammer. But secondly, I guess my question, just to piggyback on that, but a lot of hotels, they have like this language sometimes posted in the fitness room of the hotel that basically, you're using the equipment at your own risk, blah, blah, blah.
That's an assumption of risk statement that is not covered under this bill.
Right.
Which
Right.
I tried to explain to all those folks.
Right. So I just want to make sure everyone's clear for those that are listening. I'm not going to say Marriott or anybody else, that wouldn't be covered. The other question I have, so I don't have it anymore, but I used to have a membership at Planet Fitness, which is typically an adult-only health club. But I also know that if I wanted to, if I had a 16-year-old son, I could bring my 16-year-old son with me to Planet Fitness. So how, and I guess this is a question for council. So if I bring my 16-year-old son to Planet Fitness, how would this work?
Under the bill as amended, or?
Under the bill as amended.
So I can try. So I think, so the way it works, you bring they allow the son to come in under your contract.
Yes. And I signed the crazy waiver.
And there's a crack in a bar in one of the barbells that they knew about or should have known about, but you didn't. The barbell falls on him, breaks his shoulder. That's negligence on their part, not on yours. There's no contributory negligence, no assumption of risk, because he was doing everything correctly. They are going to say, well, he's excluded from being able to file a claim against us because of the waiver that you signed. And then this bill is going to say, a judge is going to say, sorry, that doesn't cut it. Because of this, we captured minors in this, you would be able to sue, and that would be enforceable.
Okay.
That waiver would not be enforceable. Excuse me.
Okay, thank you for answering my question.
Oh, Mr. Chair, I hate to do this, but I'm gonna be the contrarian here. I'm gonna be the contrarian here because this conversation has now changed my mind, as sometimes happens. Mainly, I'm done hearing this conversation. And so the quickest way to be done with this conversation, just so everybody's looking at this, we're in possession of the Senate bill. The Senate put its changes on this bill after us looking at this a number of times. And if we just say yes to what they did, we don't ever have to deal with this issue again, including in this session, and we will be done with it. And when I heard what the chair was saying about the bill originally, I said, oh, the Senate put on a lot of amendments and weird stuff. Like maybe that's a reason to stick with the clean bill. But as Delegate Cardin has now explained it, in practical matters, there's not a working hotel exemption in here. So the only thing the Senate added, in fact, is adults at gyms. One category of exclusion. I understand that, but we've made a decision to just take it like that. I mean, it's one tiny thing and the bill, or we're into an endless cycle of dealing with possible additional well, I understand. The question is whether you want to continue having that conversation this year and next or not. And I'm in the position where I think Delegate Cardin has clearly explained that we're down to just one lucky set of advocates got their people out. And actually, to be fair, the gym people were the first and only people to arrive last year, as I recall, in any manner and complain about this. And everybody else knew about this bill that we passed near unanimously twice. And now they're here talking about these additional exemptions. I'm kind of ready to move on.
Delegate Taylor, then Delegate Grammer, and then Delegate Williams, and then we're going to probably move previous. Delegate Taylor.
Ooh, I have to admit that I'm not exactly sure what this question is now, because it has changed every time somebody talks. But if I am under the Senate bill with the amendments, if there is gross negligence.
Correct.
And I get hurt as the adult, even if they're waived, they have insurance or liability insurance that would cover me. Is that right or wrong?
Yes.
Can't waive gross negligence.
Right.
It's about, that's what
Okay.
the subcommittee, I mean, the vice chair said.
So,
And the bar is higher to prove gross negligence.
so your example of the crack in the barbell,
That's not
And-
gross negligence.
Right.
that's not considered gross
Nope.
negligence.
No, that would just be,
That's
if
right.
somebody, they weren't maintaining the property as they should, that would just be simple negligence.
Yeah.
If, for example, somebody was
The alligator.
cleaning it, cracked it, and said, I'll take care of this next week. I knew it was there, but didn't do anything about it. That's then gross negligence because
Which is
he
hard to
knew
prove.
that somebody's gonna get hurt the first time they do it, they grab that bar and it falls on them. That would be the difference.
Okay, and then may I follow up?
Yes, please.
So my original question had to do with what are the differences, right? What is the difference in how we passed it as the House bill and what the Senate added? And what I'm seeing is the only additions are the hospital and the hotel and the gym memberships, right? And the adult gym memberships. If we were to go back to where we were, what did we add?
We didn't add nothing.
So it is the clean version that Delegate Grammer is referring to.
Yes.
Thank you, that helps me.
In current law is all the harms that we're talking about. To be clear, we passed no law, it's this.
Delegate Grammer, then Williams.
2 points. Delegate Tolles is exactly correct. I have a rogue, I have a rogue bench, let's say any piece of rogue weightlifting equipment. What's the difference if it's in
Being
the correct.
Not an adjective being, okay.
So what's the difference? What's the difference if Gold's Gym buys that piece of equipment? Now this law applies to them versus a hotel that buys that very same piece of equipment and should be maintaining it as the manufacturer tells them to do. What they're asking for is to be able to be negligent. That's what they're asking for. If they don't use these forms, What they're saying is we'd like an exemption because if we do use these forms, we don't want this negligent. We would like the opportunity to be negligent in the future. And, you know, I'm going to disagree with Delegate Moon here that we're never going to see this again. Because look, this is ultimately about protecting people. We're stepping into contract law and we're saying we're not going to allow this because we see these conditions which could be deleterious to consumers, and kids get hurt, adults get hurt. Sometimes it's really serious. So if we exempt hotels, we very well could be seeing this again someday because someone unfortunately was not protected. I don't think doing the exact same thing that we did unanimously a few days ago, I don't see a danger in that. And I think every now and again, this committee gets to put its damn foot down and say, we're doing the right thing and we're going to hold to that. So I believe the amendment is the right thing. I'm not surprised the chair and I are on the same page with this one. And I believe we should do what we did unanimously a few days ago, adopt the amendment and take the House version.
Delegate Williams.
Yes, Delegate Grammer stole a little bit of my thunder there. But I was just gonna say, this is about public policy. And we were sent here to make good law, not just to pass something for the sake of passing something. And I understand Delegate Moon's point, but I think we need to send a message that we're just not going to pass something just for the sake of getting it off of our desk. We should be passing it because we legitimately believe it's good public policy. And I don't think that these amendments set a tone that this is good public policy because, like Delegate Grammer said, the next industry is going to come next year and ask for an exemption, and then the next industry, and then the next industry. And we have to put our foot down somewhere. So that's where I'm at, Mr. Chair.
Good job.
All right. So the reason that I called the committee's amendment first is because I thought there might be some discussion, and it was, you know, a little bit. And there was a lot. And so I would say that, you know, the question before the committee right now, and it honestly won't hurt my feelings one way or the other, because I feel like this has been a very good debate, and I think it's been very helpful to kind of get all of this out in the open and put it out in a public forum. And now that everybody who's watching us is excruciatingly tired of hearing this, we're on the amendment. And so the amendment would take it back to the version that we sent to the Senate. We've already moved it. So now we're just going to take a vote on, and so we're doing it. I'm going to do it with a show of hands, so I'm going to take some time to do it. But all in favor of the amendment, raise your hands. There is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. All those opposed. 1, 2, 3, 4, 5. The amendment's adopted.
Second.
All right. Favorable with the amendment as the second. Takes it back to the posture. Look, at the end of the day, we're going to be in a different place than the Senate. We haven't had, I don't think we did any conference committees last year. I don't think so. First time for everything. And so we'll work it out in conference, more likely than not. I'm going to, any further discussion on the bill as amended? There was a motion in a second. Seeing none, the vice chair.
Yes.
Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman.
Yes.
Yes. Williams.
Yes.
Okay. Back it goes. All right. Leaves one bill, Senate Bill 11. Senate Bill 11 there is an amendment that I believe takes it to the same position that the House, that we passed the equivalent House bill, if I'm correct? Whose bill is this? Is, yes, Claire? It conforms it to House Bill 550, which was Delegate Williams' bill. So again, we're conforming it. We're basically, okay. So we're conforming, right? So there's a movement for motion for the amendment. All in favor of the amendment that would conform this to the House bill, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 17, 18, 20, 22. All right, anybody opposed? All right, so we're on the bill as amended to conform it to the House bill that we already sent over. Is there any further discussion on the bill? Well, wait a minute. Is there, let's do this. Is there a motion? Motion for favorable and a second. All right, now questions and discussion. Delegate Munoz.
They were filed as two totally separate bills. So can we explain what the bill is?
So what the
Yeah.
bill, they were not perfect cross files. Senate Bill was not, 11 was not a cross file. It wasn't a cross file at all. So what we're doing is this is the bill that they included their language about the procurement process and expungement. They did that in this bill. So we're just changing it to our language from the House from the bill that we passed in House Bill 550 on procurement. So it gets rid of everything else that's in the bill. It does not, as you all remember, it does not directly address whether we should do partial expungement or not, whether we should do automatic expungement or not. It requires the Department of Public Safety and Correctional Services to do procurement to be able to be ready for those things. This may be another bill that also ends up in a conference committee, but we'll find out soon enough. Any other questions about the bill? Okay, everybody's ready to go. The vice chair, yes. Munoz, no. Crutchfield, yes. Cardin, yes. Sample Hughes, yes. Embry, yes. Pasteur, yes. Tolles, yes. Schmidt, no. Simmons, yes. Boucher, yes. Phillips, yes. Roberson, yes. Tomlinson, yes. Erican, no. Taylor, yes. Simpson, yes. Grammer, yes. Moon, yes. Valentine, no. Conaway, yes. Kaufman, yes. Williams.
Yes.
All right. Yeah, so that concludes the bill hearings for today. Is this? Okay, Delegate Erican.
Thank you, Mr. Chair. I just wanted everybody to see, this is my daughter, Charlotte, right here. She's been enjoying our voting session. She's a delight. You want to say anything? Want to say hey? Okay, sorry. She doesn't like to be in the spotlight, but this is the real world, baby. It's fine.
Chair, my daughter also has been observing us and watching democracy in action. So.
All right. Thank you all very much. That concludes the vote session. Back here Monday at 1, please. Back here Monday at 1. Easter Monday at 1.